Happy New Year, everyone, and welcome to the January 2025 episode of my PIP Monthly. As always, my name is Amber Rouse Holloway, and I'm an executive partner here at our Troy office. So to start 2025 off, we're going to, of course, do a case law update. This is a very recently unpublished opinion, NuCare Therapy v. Liberty Mutual. And then moving on to trending topics in PIP litigation, we're going to briefly discuss unlawful solicitation. It seems like we're getting an uptick on the defense side in cases where this could actually be a defense. So I just felt it was important to know what to look out for in those types of cases and what kind of fact patterns typically bring up unlawful solicitation. All right. The case of NuCare Therapy v. Liberty Mutual is unpublished, but to be published, my apologies. It came down on January 7th, 2025, and ultimately this case reiterates that a clear-cut principle from the common law that relationships by marriage terminate upon the death of the spouse unless the couple have a surviving child. However, consistent grumblings about this rule from the bench put its continued viability into question. So this may not actually be the case in the future, but for now and definitely in the past, it's been a very strong principle. Now, generally speaking, when Michiganders, just as a brief background on this one, when Michiganders purchase car insurance, we are typically told that they're not just protecting themselves, but they're also protecting much of their household, including their children and their spouses. The typical no-fault policy, as we all know, applies to the accidental bodily injury, to the person named in the policy, the person's spouse, and a relative of either domiciled in the same household, i.e. their children. Now, this law's generous nature makes it easy to insure extended families, but has also invited extensive litigation, especially whether two relatives are truly domiciled in the same household. Now, this specific case probes a different phrase in the No Fault Act, regarding domicile, but this case focuses more on the relative issue, asking whether a man remained a relative of his brother-in-law after the death of the sister that connected the two men. Which is an interesting set of facts. Like, is he no longer the brother-in-law now that the sister is not alive? Now, ultimately, this case stemmed from a 2021 car accident involving a Mr. Garrell Morgan, who was seated in a parked vehicle on the side of the road when another driver crashed into him. Now, because Mr. Morgan's vehicle was uninsured, he was personally disqualified from receiving no-fault benefits. However, it was still possible for Mr. Morgan's medical providers to recover payment. Now, Mr. Morgan's treatment facilities included plaintiff here, NuCare Therapy LLC, where he received physical therapy 3 times a week after the accident. Now, first, the company needed to find an insurance policy that could cover Mr. Morgan at the time of the crash. So the company started to look for possible, NuCare started to look for possible coverage for Mr. Morgan. Now, the good news for plaintiff NuCare was that Mr. Morgan lived with his sister, Miss Regina Morgan Willis, and her husband, Mr. Thaddeus Willis, for more than 35 years. Miss Morgan Willis owned a Chevrolet Equinox that was insured by defendant Liberty Mutual. And since Mr. Morgan was his sister's relative and domiciled in the same household, her policy should have covered him, according to plaintiff here. Now, there was only one problem. Miss Morgan Willis died a year before the accident. That said, Mr. Morgan still lived with Mr. Willis, his brother-in-law, even after his sister's death. Even after the brother's death. His sister's death, my apologies. What's more, Mr. Willis maintained his wife's vehicle and the Liberty Mutual policy at the time of the crash. So long as Mr. Morgan and Mr. Willis were still related to one another, Mr. Morgan would be covered under the Liberty Mutual policy. But the question here is, are they still related? Now, ultimately, plaintiff brought a claim for no-fault benefits from defendant, arguing that Mr. Morgan and Mr. Willis were not related by blood, but were related by affinity, related by marriage, rather. The insurer moves for summary disposition, arguing that Mr. Morgan ceased to be related to his brother-in-law after the death of the sister who connected them. Now, ultimately, the trial court denied defendant's motion, finding that the two men were still related. The judge cited a very similar no-fault case of Patman v. Nationwide, which held that a man's car insurance policy covered the stepdaughter he lived with even after the death of his wife, the girl's mother. Now, defendant appealed and the Court of Appeals ultimately reversed. The panel noted that Patman was unpublished and therefore not binding. And to find a case with precedential value, the panel reached back nearly a century to the case of Shippey v. Shippey's estate. This was a probate case, and it asked whether a widow could claim payment for nursing services after taking care of her late husband's ailing elderly mother. Now, the probate case was dismissed on the grounds that the two women were related, so the widow's nursing care was presumed to be a favor. Now, the Supreme Court affirmed that because plaintiff and her late husband had a daughter, citing the traditional rule that relationships by marriage survive the death of a spouse, so long as the married couple have a living child. The case, a good quote from the case is, death of a spouse terminates the relationship by affinity. If, however, the marriage has resulted in issue, meaning a child that's still living, the relationship by affinity continues. Now, the reasoning in this Shippey case from a century ago may seem unintuitive today or even antiquated, but the Supreme Court did affirm Shippey as recently as 2023 in the case of Henry Greeblack Trust. Now, the court ultimately here said Shippey remains good law. The leading opinion in NuCare applied its holding, making the existence of a surviving child, the dispositive question. So again, it's important to look to that fact pattern when you're deposing parties in which this may be an issue. Ask about, and sometimes, well, for me, I always ask about the plaintiff's children, the prior marriages, those questions that may not seem important at the time of a deposition, or even at the time of, for my adjusters listening, at the time of initial conversations with the insured, can come in handy and be a really big factor when determining disposition of these types of cases. Now, moving on to trending topics in PIP litigation. Again, I wanted to talk about unlawful solicitation and specific fact patterns that could bring up this issue. Now, ultimately, the Michigan Penal Code criminalizes direct solicitation to provide a service to an individual injured in a motor vehicle accident or an immediate family member of the injured individual for any reason within 30 days of the motor vehicle accident. Now, this is commonly called ambulance chasing. And funny enough, I just saw, I believe, what was a Super Bowl ad of a very popular plaintiff firm in our area that had the very popular attorney running after an ambulance because the ambulance driver dropped his wallet. But all the news captured was him running after an ambulance. It's pretty funny. But the statute of the unlawful solicitation statute extends to any person, firm, co-partnership, association, organization of any kind, or any of the officers, agents, servants, employees, or members. So that means not only the attorneys, but these plaintiffs' firms may hire individuals to do this, and their specific goal is to chase ambulances, for a lack of a better word, or to randomly, in practice, what we see is all of a sudden a plaintiff gets into a car accident and then they start getting calls, or all of a sudden a plaintiff is even at the hospital and then someone walks in their room. I've seen it all, but the most common fact pattern is the cold calling of an individual that was just recently involved in a car accident. Now, the term direct unlawful solicitation means a verbal or written solicitation or offer, including by electronic means, made to the injured individual or a family member seeking to provide a service for a fee or other remuneration that is based upon the knowledge or belief that that individual has sustained a personal injury as a direct result of a motor vehicle accident, and that is directed towards that individual or family member. Now, under the case of Hightower v. Detroit Edison, a 1993 case, there was a plaintiff here, a 7-year-old, that was injured by a defendant's truck, a Detroit Edison truck. Plaintiff was living and supported by their great aunt. Her name was Mrs. Powell, who was a friend of the court in this case. A few days after the injury, Mrs. Powell was contacted by a representative of J.C. Donahue, who worked under the business name of Michigan Accident Claims Company, to place a claim with Donahue. Powell was told that Donahue was a lawyer and that suit would be commenced. Next day, she signed papers at Donahue's office. Now, when the suit was commenced, an attorney by the name of Griffith was appointed as plaintiff's lawyer, and a lien was filed for his services on settlement, recovery, or judgment. Griffith did not try the case, but was substituted by appellant, an attorney as well, who was chosen by Donahue, not Mrs. Powell. After Mrs. Powell inadvertently told the court that she was solicited, the court denied Griffith and appellant any fees or liens on the ground that the claim had been solicited in violation of the statute and that Donahue was illegally practicing law through Griffith and an appellant. Now, ultimately here, the court determined that there was ample evidence in the record by way of former dealings and the appellant's information that Donahue's practices and the character of his business to have put a reasonable person on inquiry and charged with him the knowledge that someone had been solicited. Now, the court pointed out that the rights and duties arising out of the relationship of an attorney and client are extremely personal, and that the lawyer owes his client undivided allegiance, and there is no place in the relationship for the establishment by a middleman having an interest or control of that procedural relationship. Now, ultimately, the solicitation is discovered a lot of times through the deposition of a plaintiff, but in practice, as adjusters and as attorneys, we all know the heavy hitters for solicitation. So when you get a case and you hear that a plaintiff has been treating with the identical treaters as many other plaintiffs, that should kind of put your antennas up. But the issue now is that plaintiffs are becoming coached. They're becoming more savvy about the solicitation. They don't mind being solicited, even though I don't feel as if they quite understand the gravity of and the cons of being solicited. They don't have a problem with it. But nevertheless, the law is what the law is, and it's there for a reason, and solicitation is improper for a reason. So it's important to, again, just like for the case law update, to ask those questions. How did you hear about this place you were treated at? Or how long after the accident did you contact an attorney? Meaning, I don't want to know what you talked about with that attorney, but how long after the accident did you contact an attorney? Or did you contact an attorney? Or did an attorney contact you? So these questions that may seem overlooked and trivial can become important throughout litigation and for the disposition of a case. And that is all I have for you guys today. As always, thank you for attending the very first episode of 2025. My name is Amber Rouse Holloway. Please feel free to contact me with any questions and or concerns.